welcome. Linda Greenhouse has been here once before.
At least once.
At least once, and it's a real pleasure for me to have her back. I'm not a lawyer myself, but I spent many.
But you play one on TV.
I do. Yeah, I play one on TV. But I spent many hours in the Supreme Court after I came to the Senate because I was not a lawyer, and I started off being an advocate of televising the court because it's the one place of the three branches of government where I do think that the debate that occurs on the court would increase people's confidence that democracy is working. It's the critical thinking on the court, the nature of the arguments. I've come actually to the view held by David Souter that it would probably ruin the court if the televisions were turned on. So if you ever get a chance to go down and hear an oral argument, I would recommend that you do it. The format here, if you don't know, is we'll have a conversation for an hour, and then you all can ask questions, and Linda will answer those, and then at 7:30 we'll bring the curtain down. Linda Greenhouse covered the court, I think, 30 years for the New York Times. Won a Pulitzer Prize, 9 honorary degrees. Member of the Academy of Arts and Sciences, and member now of the Yale faculty. And I think an honorary member of the bar, if I approximately, or somewhere along those lines. But let me open with the piece that you wrote on Justice Breyer, talking about his understanding of the relationship between the court and the Congress versus the relationship that Justice Scalia, though he doesn't mention him by name, has between the court and the Congress. Because, just say this, I don't know how many of you ever watched confirmation hearings, but among the things that I'll just put it this way, I think nominees have gotten away with is almost a silly, but nonetheless it's sold, assertion that all I do on the court is act as a referee, an umpire. I just call balls and strikes. That's all I do. I don't bring my ideology. And I say it's silly because it's impossible not to bring your ideology. That's the whole idea when you're interpreting either the law or the Constitution. So let me just ask you to just comment on, because I haven't read the book, on what it is that Breyer is saying versus what it is that Scalia says about the Constitution and the court and the Congress.
So Stephen Breyer has a new book called, I think it's called Making Our Democracy Work. I'm blanking on the exact name of it. But it's his stance toward the work of the court. And what I wrote about was what I found the most original and interesting part of it wasn't his constitutional theory, which is perfectly interesting, and which he articulates in a number of cases and in a previous book, but what he says about how the court should relate to Congress. Because I think what people tend not to realize is that the kind of day in and day out work of the Supreme Court isn't so much, dealing with the great constitutional principles of the age, but it's interpreting statutes. And of course, we live by our, statutory regime on a day-to-day basis, whether it's pension law, health care, labor law, whatever, really much more than we encounter kind of the Constitution raw. So it's really important what the court makes of the language that Congress drafts for bills. And as you know better than anybody, it's often ambiguous. It often reflects unresolved tensions. It's often a compromise that ends up with saying, let the Supreme Court figure it out. So what is the court supposed to do? And Breyer's main shtick in this book is to say, our job is to do some work and figure out what was the purpose of this legislation and not get hung up on inartful language or internal contradictions, but to help Congress basically be the best it can be by discerning what it meant. And he says, now, of course, you can critique that by saying, who could tell what it meant, what 535 people meant? Maybe they didn't mean anything. Maybe most of them didn't read the bill, as I assume is often the case. That doesn't matter. We interpret, we ascribe intent to all kinds of collective organizations, to corporations, to collective bodies, and it becomes clear through legislative history, committee reports, floor statements, and whatever, what the drafters of the legislation intended, and you can infer what Congress meant. And of course, if it's a matter of statutory interpretation and you get it wrong, as the court in recent years has, Congress can change it. Now, how that differs from Justice Scalia's approach is Justice Scalia says legislative history is phony. Staffers will just cobble something up after the fact. It doesn't reflect any kind of reality. It's just a political game. And I'm not going to, not only am I not going to rely on it, I'm not going to cite it. And I'm not going to sign my name to any portion of any opinion that cites it. And basically he's saying, I'm going to disable myself from actually trying to figure out what Congress meant. And if Congress doesn't like it, too bad for them. So it's really two different ideas of sort of how the court is supposed to be a partner with a coordinate branch of government to do the best work for the country.
Do you think it's born of the two men's experience? Because Scalia had, I would say, an unpleasant experience working in the executive branch, and Breyer had a more pleasant experience working for the Judiciary Committee in the Senate.
Well, yeah, I mean, Breyer, I think if he were here, I don't want to put words in his mouth, but I think if he were here speaking candidly, he'd say the best job he ever had was chief counsel of the Senate Judiciary Committee under Ted Kennedy. And he did a lot of heavy lifting and was, of course, it was kind of a golden age in Congress compared to today, but, what wouldn't be compared to today? So, it's like compared to what? But, they did all kinds of stuff, sentencing guidelines, airline deregulation, and the key point, I think Breyer's, the background of the respect in which Breyer holds Congress is that he really worked in a bipartisan way, and people could really talk to each other across the aisle, staff and members. And in fact, Breyer was so well respected across the aisle that he was confirmed to the First Circuit, to which President Carter had nominated him after Carter had lost the presidency and the Democrats had lost the Senate in the 1980 election. Breyer was confirmed in a lame duck session in December of 1980, and he was the last Democratic appointee to be confirmed to any federal court until Bill Clinton came in. I mean, it was like amazing because the Republicans were willing to vote for him. So anyway, that's a long answer, but it's just interesting because I think biography really is interesting.
But so take the Scalia experience.
So
He was in the Nixon White House.
Yeah, I don't know if Scalia had a bad experience. He was head of the Administrative Conference of the U.S. He was Assistant Attorney General for the Office of Legal Counsel, which is a pretty good job. Mm-hmm. I mean, in those days anyway. People didn't get, indicted for writing torture memos and stuff.
But he was Nixon never had a majority Republican in the Congress. And the Congress could be relatively hostile to up to and including impeaching him. So
well, I think Scalia would pride himself on a kind of realpolitik that would say, they're just making stuff up, and I don't have to give it any credence. I don't trust them. I don't like them.
So I'm going to take a specific statute, that the Americans with Disability Act, which extended a new right.
Major civil rights legislation.
Major civil rights legislation, bipartisan legislation.
Right.
That was passed in the 90s as an example of the sort of thing that this fault line between Scalia and Breyer.
Okay, so the court has been very stingy about interpreting the ADA. I'm not sure if that's the...
You've got nothing in your memory bank that...
No, my memory is that, so the question in the ADA is, what's a disability? It gives all kinds of rights to people with disabilities, but it doesn't really define what's a disability, and it's been left up to the courts. And so various situations have come up.
And that, by the way, was a compromise.
That was a compromise, right. So situations have come up, and the court has basically held for a non-disability, and Congress had to go back this last year and amend the statute and make clear that they meant more than, even today's Congress meant more than the court seems to have thought they meant. So that maybe
And you think, but in that case, did Scalia black out the intent of the Congress and disregard what the
in one of those ADA cases? Yeah, I'm sure. I mean, pick up any case of statutory interpretation, even one where the vote is 9-0, and you'll have a little statement from Scalia. Justice Scalia joins all but the third paragraph in Part 4B, because that's the part where the court acknowledges that there's such a thing as legislative history. So the example that Breyer gives, or one of the examples that Breyer gives in the book, has to do with another disability-related law, the IDEA, Individuals with Disabilities Education Act, which is the statute that requires that all children are entitled to a free public education, to the best of their ability. I'm not quite phrasing it right. So this is often, as people know, quite contentious, and the public school system will say, we're making all the accommodations that we're required to. The parents will say, no, you're not, and it goes to a hearing, and the parents often have to hire expert witnesses to make the case of what's the child's diagnosis and what's the child's ability, and so on. It's very expensive. So the question in this particular case a few years ago was, when the parents win, as they often do, can they get those costs covered by the school district? And the court parsed out the language of the statute and said, no, they can't. And with Scalia in the majority, and Breyer wrote a dissenting opinion saying, look at the purpose of the statute. Don't get hung up on the language. And I forget the exact word that it turned out, but the purpose is to enable parents to get their children the best education available, and if they have to expend money to do it because the school district is recalcitrant, they should get, and they win, they prevail, they should get reimbursed. They shouldn't have to bankrupt themselves to get what ultimately is determined to be their statutory entitlement. So that would be an example.
Can you give us your sense of what you think the Chief Justice is apt to do in response, not necessarily in response, but you pointed out that Rehnquist came to bat during a Republican administration to try to move justice along. And my somewhere between expectation and fear, a little closer to fear, is that in January, the Democratic majority is going to be reduced to 52 or 53.
Oh, you're an optimist.
I am an optimist. You're right. So do you expect, making it even more difficult in the confirmation process and increasing the numbers likely of vacancies on the court?
Yeah, what Bob is referring to is an op-ed I wrote last week, on which I said in 1997, Clinton in the White House, Republicans controlled the Senate, and they were just sitting on Clinton's judicial nominees, and Chief Justice Rehnquist, in kind of a Nixon in China moment, used his annual year-end address on the state of the judiciary to say, move these nominations. He was saying, I'm not saying you should confirm all of them, but they're all entitled to a vote, and if you don't like them, vote them down and let the president pick somebody else, but it's a crisis when we have all these vacancies on the judiciary. Well, now, of course, it's a Democratic Congress, but it's a whole different atmosphere. Now there's an even larger proportion of vacancies. And, and for instance, Congress left last month, leaving 23 nominees hanging, I think 16 of whom had received unanimous votes out of the Judiciary Committee. So there's not an ideological issue. It's not that the Republicans can articulate any problem they have with these.
Jim DeMint's not on the Judiciary Committee. If he was on, he would have voted no.
Okay,
probably.
Good point.
And that's
anyway.
If there's opposition, it's apt to come from, let's say, Jim DeMint. If Joe Miller wins in Alaska, he's going to be in that group. I mean, he'll command a a cluster of 8 or 10, I would guess, of people who basically are going to say, hell no, we won't go until
Right.
2013.
Right. I mean, it reflects, I think, a collective determination, by leadership determination. We're just not going to do it. And what's, now, of course, people say, well, the Democrats did it too. Well, that's true. But the Democrats blocked a handful of Court of Appeals nominees for ideological reasons. You can debate that. You can say they should have or they shouldn't have. But they had a reason they could articulate for each one that they blocked, like Miguel Estrada for the DC Circuit, highly qualified, fine guy, just very conservative. And the Democrats knew if he were sitting on the DC Circuit, he'd be in immediate launch position to the Supreme Court. So, maybe they did the wrong thing, but at least they could articulate a reason. What the Republicans are doing are blocking district court nominees whose names nobody's ever going to know. I mean, they're blocking the promotion of federal magistrate judges to the U.S. district courts. It's just across the board. Anyway, so my column pointed out that Rehnquist had stuck his neck out and said, do something about this. And I was saying, Chief Justice Roberts, your year-end report is coming up, and your chambers is probably working on it already, and, what about it?
Yeah, my own belief is unless Roberts does, the public is not apt to be paying attention to the issues. Not apt to be much of a price paid by the minority, let's hope, blocking these nominees, would be my guess.
Oh, yeah. I mean, the public doesn't seem to care. And, one could say the progressive community doesn't care enough. You can say the president doesn't care enough. I mean, you can certainly critique the Obama administration for having been slow to nominate people to the various court. No, they were stuck with 2 Supreme Court vacancies in their first 18 months. But, they were quite slow to nominate people to the lower courts. And the president obviously has had other fish to fry and hasn't made it a huge priority. So, there are many reasons for the current situation. But it's not a good situation.
I just was down yesterday in Washington, I was telling you before we came in here, to be on a panel about the Moynihan book that just came out, his letters and memorandums. And you did a book on Blackmun, based upon his writings as well. In fact, I think entirely, as you said, based upon
his collected papers.
His collected papers. And then you, sometime in the last few days, you've got a piece in one of your pieces in the Times talks about Potter Stewart's papers opening up in the Yale Library, and that Souter, unfortunately, has put a cover on his for 50 years.
Yeah,
Well, talk about the importance of these papers and what it does to illuminate history and help people understand. And talk as well about whether or not you think we're going to see a diminishing number of people with the courage to keep a journal and make it available to the public after they die.
Well, it's up to each individual justice. There's no rule. There's a consensus now that people should put conditions on their papers so they're closed until everybody they served with has left the court or has left this earth, one or the other. Potter Stewart, who left the court in 1981, his papers just opened this summer because the condition he put on it was not until everybody I served with has left the court, and the last person he had served with was John Paul Stevens. So the day after Stevens retired, the Potter Stewart papers opened at Yale, his alma mater. People were, I think, upset with Harry Blackmun, who he said the paper should open 5 years after his death. So he lived for 5 years after he retired. And then 5 years after that, the papers opened in 2004. And 10 years is, it's not like a blink of an eye. But what happened was, in those 10 years, nobody else had retired. So his papers provided a window on the entire court that was then sitting, except for Stephen Breyer, who replaced him. So it was a much more intimate look at the current court than one might have anticipated, because 10 years without a vacancy is a historically long time. And so nobody else is going to do that. And in fact, Sandra O'Connor was asked about this in some public forum. I wasn't there. The name of my Blackmun biography is Becoming Justice Blackmun. So Justice O'Connor was asked what she's going to do with her papers, and she said, no, she wasn't sure, blah, blah, blah. But she said, I'll tell you one thing, there's not going to be any Becoming Justice O'Connor. So
That's too bad.
So I have a new book out, if you want to ask me about that.
Yeah,
welcome to. Which is over there on the table.
Tell me about your new book.
So the new book is also based on documents. It's a collection of documents that illuminates the history of the abortion debate in this country.
Oh, the Voices book.
In the 10 or 15 years before Roe against Wade. It's an effort to reconstruct the landscape on which Roe fell. All sides of the debate, and I say all sides, not just two sides, many sides, as the question of reforming the 19th century laws that in every state made abortion a crime came to prominence, and how it started and who opposed it and so on. And the documents are social movement documents, litigation documents, things from the popular press, things from personal papers of people who were involved in this. So that was quite a lot of fun.
We'll talk about some of the more interesting ones on both sides, because I don't really have a memory of pre-Roe.
People don't. I mean, it's really interesting, and you lived through it, and I lived through it.
Right.
I wrote about it at the time even. But it's just very hard to throw our minds back to that time because
Well, I'll tell you, if you see a continuation of the current polling trends, it's likely that in the next 5 years that Roe gets overturned. Certainly in the next 10 years, because it's likely you'll have a Republican president, and likely you'll have changes on the court, and there won't be another suitor nominated by a Republican president.
I agree with that.
Promise
No,
you.
I agree with you. I think if John Roberts had 5 votes, Roe would be overturned in a heartbeat. And he doesn't have 5 votes because Anthony Kennedy is sitting there. No, I think that's correct. So, we see the period that led up to Roe kind of through the lens of Roe, and it's a distorting lens because it kind of fills our landscape. But what's interesting was to see, for instance, we now regard sort of religious activists as categorically anti-abortion. And certainly the Catholic Church always has been. But in the years before Roe, the evangelical churches, in fact, the trade organization, the National Association of Evangelicals, did not have a position of categorical opposition to abortion. They were willing to sign up with the American Law Institute's reform position, which allowed abortion for certain indications of, health and maternal health and fetal health and so on. So positions were much more fluid. The conversation was, people were grappling with this and hadn't necessarily come to sort of hard and fast positions, and in fact didn't until the late 1970s, some years after Roe. So one thing, the book kind of stops at Roe, so this I'm arguing something that goes beyond the book, but my co-author, Reva, Siegel, and I have just finished a big law review article that kind of carries the story forward. It wasn't until the late 70s and the rise of Ronald Reagan that the evangelicals, who were very much interested in opposing ratification of the Equal Rights Amendment and the whole kind of family values agenda, joined forces with the Catholic Church, and they had never been allies much of anything, to make using abortion as kind of a bridging issue between them to make a strong coalition, anti-abortion coalition. I mean, Jerry Falwell, for instance, founder of Moral Majority, didn't preach his first sermon against abortion until 1979. So, people think, there's this whole theory that the court decided Roe against Wade, and that caused this huge backlash, and everybody said, oh my God, we have to line up and, in our battle lines, and actually that's not true. Roe was kind of I won't say it was a blip, but it wasn't the galvanizing event. The galvanizing event was really the coming together of socially conservative political forces around abortion as one of a whole bunch of other issues. So it's a very interesting tale. It's one of those things where, you think you know what happened, but I mean, I learned a lot in doing the research, I'll just say that.
My memory correct, there was at first a flurry of potential opposition to Ruth Bader Ginsburg based upon something that she had written where she cited...
No, not quite, no.
But as I recall, what was going on was she disagreed with the basis of Roe v. Wade.
Well, the Ginsburg thing, of course, she was a great, women's rights advocate and completely pro-choice. I mean, that wasn't the issue. She gave a major law school lecture in the mid-'80s in which she said she thought that the court would have done a better job with the abortion issue and kind of insulated the opinion from the attacks from the legal academy had it rested the opinion on an equal protection claim
on a 14th Amendment
rather than substantive due process, right to privacy. Now, I mean, I love Ruth Bader Ginsburg, but I don't agree with her on that because I think it's not a historically correct analysis because by 1973, as she knows because she made this law, the court had yet to adopt an interpretation of the Equal Protection Clause of the 14th Amendment to make sex discrimination a constitutionally suspect category. They hadn't done it yet. They did it later, a few years later, because of her, because of cases that she was bringing. But at the time, that wasn't...
so they couldn't have argued on that.
That wasn't language that was available to them. And in fact, there were equal protection arguments made to the court in Roe, and in the appendix to this book, we excerpt all the briefs that were filed to the court in Roe because it's just very interesting to see what were the arguments that the justices had available to them. What were they learning by what the advocates told them? So there was an equal protection claim, but it wasn't equal protection for women. It was equal protection as between rich and poor, and the argument being that wealthy or middle-class women could get safe abortions even if they were illegal, one way or another. And it was the poor women and women of color who were finding themselves in the back alley getting dangerous abortions. And so in those days, the legal argument was available to people to say that poverty is a status of special constitutional concern. And the court, rather soon thereafter, the Berger Court, ruled that out of the Constitution in a case that had to do with school finance. It had nothing to do with abortion. So that's an argument that people don't think of today because it's not available. It's not in our constitutional discourse today. But that was a powerful claim in those days.
So what, in your view, would the country look like if Roe was overturned? Since you've done extensive research on what the country was like pre-Roe.
Well, of course, if Roe's overturned, it doesn't make abortion illegal. It frees states to do what they want. So we'd have a red state, blue state situation, as we kind of do now, because we have a bunch of red states that are constantly pressing the envelope and have been.
Nebraska and Carhartt was one.
Oh, Nebraska is like, I mean, excuse me.
I know it well.
Yeah. So, so Nebraska.
Carhartt, by the way, was a little provocative. I mean, he opened his clinic up right next to a Catholic church in South Omaha. So
good for him.
Well,
right? Put him right to it.
Not good for all of us who were trying to defend him.
Yeah, right. But so Nebraska now is, so Nebraska, I don't want to pick on Nebraska. They're, one of many states. Right. I mean, I'll say this: Kansas is even worse. But if that makes you feel better, but but so they've been trying doggedly ever since Roe to set up various obstacles, and the legal history of abortion since Roe is a history of the court responding one way or the other to these various obstacles. So the latest one. There are two now sort of coming down the pike. One is, and I forget which state is doing which, but they all get their marching orders, and a lot of states are doing this. These phony informed consent requirements that require the doctor to read to the woman a bunch of inaccurate information, such as, abortion is a terrible trauma and you'll suffer mentally, if you go through with this, it's your right to go through with this, but if you do it, you'll really pay a heavy psychological price, which is false. I mean, it's like completely false, and I could go into that more, but I won't take the time. And all kinds of stuff. So it's the state requiring doctors to lie to their patients. It's really offensive, and that's out there, coming up in the legal pipeline. And then the other one are these ultrasound laws that require the doctors to, at least they can't force the woman to look, you can close your eyes, but to offer the opportunity to see an ultrasound of the fetus before the abortion. And
ultrasound,
again,
by the way, has definitely changed the abortion debate. It has changed the abortion debate.
Yeah, well, and of course, one thing that changed it, and again, this is one of the things we don't necessarily realize was so recent, were photographic images of the fetus.
Right.
And a very brilliant strategist of the Right to Life cause, Dr. Jack Wilkie, whose name people know or not. Does that name ring a bell with anybody? No, see, that's interesting. So Dr. Wilkie, who's still alive, he's in his 80s, was the founder of the National Right to Life Committee, and just, a brilliant political strategist for his cause. And he wrote in 1970, self-published, a little book called Handbook on Abortion, a very small book that would fit in your pocket. And it contained these very graphic photographs, and also in a kind of a catechism way, a question and answer about abortion. And it sold like hotcakes. I mean, millions of copies of this book are sold. You can go on Amazon and get it, as I have many copies of it, like I show to people. And the use of these photographs was very key, even back then. I mean, one of our triumphs in gathering the documents for this book, of course, you have to get permission before you start reprinting people's work. So that was a big obstacle to get, copyright permission. And the Betty Friedan estate wanted to charge a lot. People were like charging us money, thousands of dollars to print stuff. But we really wanted to print excerpts from Handbook on Abortion because, as I say, all sides are represented in this. And the Right to Life side studies the pro-choice side very closely. The pro-choice side really is ignorant about the discourse on the other side. So nobody on the pro-choice side has heard of this book, which, as I say, is like available in 34 languages and gazillions of copies. And so we spent a long time persuading Dr. Wilkie that we couldn't authentically represent his side of the debate without being able to use his words. And he gave us permission. And he said, all I ask is that you send me 2 copies of the book. So we sent him 2 copies of the book and waited a while and then got a letter from him.
It is a very effective book and very effective. It's sort of part of the American tradition of pamphleting as far as I'm concerned.
It's that book, right.
Yeah.
I'm sure you've seen it.
Yes, I have.
And Dr. Wilkie wrote...
I've been sent many copies.
He wrote to us about a month ago and said, I didn't expect too much from you when I gave you permission to use my book, but he said, I've read your book, and it's the most fair treatment of our side by a book in general circulation that he's ever seen. So we took that as a great compliment, because that was, the effort was just to fairly represent all the points of view.
Let me ask you if you feel this way. Maybe you have many more experiences with oral arguments than I do and have followed the court much more seriously. But I find the court and the process to be, and the oral arguments and the capacity to acquire standing, which I would like to talk to you a little bit about, I find it to be quite inspiring. Because I do think the arguments are, for the most part, presented in very civil ways, and the debate, the standards for the debate are quite high. And I'm curious, do you feel the same way after watching it? Do you still feel that way about the court after watching it for 30 years?
Oh, I do, and I mean, with all due respect to Congress, I often contrast the court's performance in oral argument to the Senate's performance in a committee hearing, say, right? Where the members are wandering in and out, and the follow-up.
That's why we don't elect judges at the federal level.
Right. And, and the follow-up questions come from staff,
Right.
and, this kind of thing. I mean, how many times did I see Strom Thurmond, struggle to read the question that is, The justices are up there without staff, and they're very prepared, and they ask their own questions, and, it's a very hot bench in that sense. And, of course, the quality of advocacy has, I think, improved over the years. I mean, some people critique it because there's a smaller and smaller, intense little cadre of Supreme Court advocates who get.
And Roberts was one of the best.
He was one of the best, definitely. And sometimes when you see him on the bench, he's still acting like he's on the other side of the bench. I mean, he can think of better answers, and he gets very annoyed if the advocate doesn't give the answer that he thinks, should be given. But setting that aside, so yeah, it's a very high level.
What's your opinion on televising the proceedings?
Oh, I think it would be good. I mean, I don't think it would bring about a revolution in public understanding of the court. I don't think it would hurt the court. I'm not sure. I think it'd be better than not. I'm not a huge, it's not a big issue of mine because I think, my policy when I was covering the court was never to go to an oral argument that I hadn't read all the briefs in, because you wander in there and you have no idea what they're talking about. Because in a Supreme Court argument, there's never a point where the lawyer gets up and says, may it please the court, my client was such and such, and this is what happened, and this is what happened, and that's why we're here. They plunge in immediately to the heart of the legal issue. It's assumed that the justices know the facts and know the history of the case, and they just get to the heart of it. If you haven't read the briefs, you can't even tell if you're in the right argument. So, if this were televised just gavel to gavel, it would be kind of a show, but people wouldn't necessarily understand it. But that being aside, I think it would be a good thing.
Yeah,
but John Roberts has actually made a few good moves in terms of transparency, not transparency so much, but no, not transparency. He closed the courthouse door, which you probably heard about, which is anti-transparency. But he made the decision to put all the transcripts up on the same day. And the court has a pretty robust website, supremecourt.gov. They put up all the briefs. They put up the opinion within minutes of it being issued, transcripts the same day. And this term for the first time, they're putting up the audio of all the arguments of the week on the website on Fridays. So on Fridays, you can go on the court website and hear all the cases that were argued that week.
Did you watch the State of the Union speech in which the president called out the justices over citizens? I have strong disagreements with my Democratic friends who thought that was a good thing to do. I did not think it was a good thing to do. How do you feel about that?
Ambiguous. I mean, ambivalent, I should say.
Let me tell you why I'm uncomfortable. I think it was wrong. I mean, the justices are invited and are defenseless.
My sense of it was, it was badly. I know nothing. Well, I know a little bit actually. I think it was badly staffed because I actually, as I was watching the speech, I actually had the text that the White House had put out in advance, like a couple hours in advance, and I was following it. And the president was following it too, but then it suddenly dawned on him that the justices were, about as far from him as the 5th or 6th row here. And you could kind of see, if you go back and look at it, oh my God, he's saying, am I really going to say this to their faces? He had this text, right, or on the teleprompter. So he changed it, and he added the phrase, with all due respect to the separation of powers, as an introduction. He was trying to, soften it a little bit. So it's like kind of, did they really think the whole thing through? I mean, I think it was, I don't think it was a bad political move. It was effective in calling public attention to Citizens United, to the case. And that's been an ongoing, I think that has energized a big swath of the public to kind of take a look at the court, and it's an opinion.
But he picked a case that was 80% disapproved of by the public.
Right, including by Republicans.
Right. Anyway, but
yeah,
enough on that. I don't think I don't think a president at a state might actually feel rather strongly about it. Should not call out the court while they're sitting down. It'd be like calling out a general for something that they had done.
Yeah, no, I mean, I take that point, and you certainly wouldn't want it to have become like a standard thing. Of course, he may not have that chance because I'm not sure they're ever going to go again. But apparently, Alito has said publicly he's not going to go this year.
Oh, is that true?
Yeah, I mean, I guess, I don't know. But
I'm sure they'll find somebody else to take his seat.
It was just a weird thing.
Tell us what standing is and why standing before the court is important and why it could become an important issue in the current session of the court. What does it take if somebody in this room says, I'm going to bring a case? What does it take to have standing?
Well, there's, okay, so I hope I can resurrect this in my mind. So the standing doctrine has three parts. There has to be injury in fact. That's a term of art. You have to be concrete injury. I mean, not physical injury. You have to claim that whatever you're complaining about has injured you directly. Mm-hmm. You have to show causation, that it's the statute or the action that caused that injury. And then you have to show redressability, that the remedy you seek is going to fix it. So these are three things: injury in fact, causation, redressability. Right, so
just stopping there, again, it's one of the things that, and this is really poorly understood, I think, by the public, because the court that's also one of the reasons I did not like what President Obama did. The court's very vulnerable. Politically, they're vulnerable. And because people don't understand why they have lifetime appointments, why they appear to be unaccountable. That's one of the things that you commonly hear from people. So they're unaccountable, they're making law, all that sort of stuff. But what I find to be quite powerful is that a citizen who can prove all three of those things and brings a claim against the Congress could have standing in front of the Supreme Court of the United States.
Yes.
Could, if they bring it up, if the court decides to reach out and bring a federal case
but
up.
For instance, you don't have, an individual doesn't have standing. There's no such thing in our system as taxpayer standing. So if Congress has done something, like really boneheaded, and you say to yourself, I don't want to live in a country where there's such a stupid law, and I'm going to go to court, that doesn't get you.
Take Brady bill, the Brady bill, which I voted for, which is a restriction on gun ownership that required
the sheriff.
Right, and the sheriff had standing.
Yes, the sheriff had standing because the statute required him as a state official to do the background check.
Exactly.
So it had a direct impact on him.
Right.
And he said, this violates my sovereign authority as an officer of the state of, what was
Arizona.
Yeah, whatever state it was.
Again.
Right. So, so the reason that I think the reason you bring it up now, so the Roberts Court, and indeed the Rehnquist Court before that, were cutting back and back and back on standing. So now we have the Proposition 8 case, the same-sex marriage case in California, where, of course, as we all know in this room, the federal district judge overturned Proposition 8 and said there's the constitutional right to same-sex marriage, and the state of California has declined to appeal that. So the question is, do the interveners, the people who were allowed to come into court to defend Proposition 8, can they take the appeal when the state, they stand in the shoes of the state? And Judge Walker said they don't have standing, and this is going to be argued on appeal before the Ninth Circuit early in December. So I think.
And what's the makeup of the Ninth Circuit? I mean, I don't even know who will be heard by.
Well, the Ninth Circuit is huge, and it's going to go before a 3-judge panel. And I heard the names of the judges. I didn't know all the judges, but I saw a blog post about it that said that it's a panel that is not likely to be favorable to the pro-Proposition 8, the anti-same-sex marriage crowd, but who knows? This is really a kind of a novel question. I'm not sure there's a lot of law on the question of whether, when something has been enacted by a public referendum, as Proposition 8 has been, but yet the state declines to defend it in court, can some other group come in and say, you know, the public chose this and we're here to defend it even though the state isn't? I don't know. I mean, it's really like a new territory.
With both gubernatorial candidates agreeing on the issue.
Right. It's not a...
I promise if elected, I'm not going to appeal.
Right. So it's sort of off the table politically.
Do you think
California.
Justice Scalia would like to take the case up?
Well, so it puts them to a dilemma. They don't like standing, but let's assume they don't like same-sex marriage either as a constitutional right. So though the same justices who might like to get at that issue are the same justices who don't like standing. So they have kind of a dilemma. How this is going to play out, I have no idea because the Ninth Circuit is far from ruling on this, and it can, you know, go to a 3-judge panel, then it could go to a bigger panel. It could take like a long time. So it's going to be a while before we get the answer to that.
It's a little early to start questions, but I like to start them. The last time I waited too long, and there was way more questions than I had time for.
So we have cards, right?
You have cards? Oh my God, look at all these cards. It's like
People
an
have
auction.
cards, right?
I feel like I'm selling something up here. This is a question having to do with the recently passed health care bill. And the question is if the House goes Republican, I think it's likely, and I can't remember if he says the Senate remains Democratic. I'm not sure that, says, well, what's the likelihood the Supreme Court case is going to be taken up by the court? I'm not sure the election is going to have much of an impact on that.
I mean, what will have the impact is whether the federal circuits, whether there ends up being a conflict in the circuits over the constitutionality of aspects of the health care bill. And
have you followed it in detail? I mean,
yeah, I'm trying to follow it closely. You know, a few months ago, I would have said, you know, there's no way the Supreme Court would ever consider striking down this major piece of legislation as beyond the power of Congress. Now, I'm not so sure. I think the Justice Department is taking this very seriously right now. There's not yet a decision at the circuit court level. There's a decision that upheld or rejected the challenge in a federal district court in Michigan. There was a decision a couple weeks ago from a federal district judge, like a preliminary ruling in Florida, who strongly suggested that he thinks the law is unconstitutional. So the Supreme Court thinks one of the most important things it does is make sure that federal statutes mean the same thing in every federal circuit. And if there's a conflict, they'll certainly take it. And I mean, if the...
But you can almost predict a conflict on this one, I think.
Sorry?
I think you can almost predict a conflict.
Yeah, I mean, it seems that way. It seems headed that way. And there, Judge Hudson in the Eastern District of Virginia is going to rule that it's unconstitutional. I mean, there's a lot of things in motion right now. There's somebody running for Attorney General in Connecticut who's advertising on the radio, if I'm elected, I'm going to join the 26 states who are challenging it. The whole thing is getting, it's like...
I actually would, frankly, I'd be surprised if some portions of the bill aren't ruled unconstitutional. Because it seems to me there was not, and it's my own...
Would you have voted for it?
Yeah, I would have voted for it. But it wouldn't have been the first thing I voted for that was ruled unconstitutional by a court that I liked. So, I mean, it's...
So why do you think it's unconstitutional?
Oh, I think the most questionable piece is a federal mandate that I have to purchase something. I think that's apt to be the thing that's...
So that's the vulnerable point, and it comes down to, as I understand it, and my understanding...
By the way, I don't mind it since it's going to be young people buying it, subsidizing me, but if I was 22, I don't know how much I'd...
Right, don't take my Medicare. I hate the federal government, but don't take my Medicare. I mean, so the issue with the mandate is it a... So you have to pay...
Mandate and penalties imposed.
Mandate and penalties. So the issue is, so the mandate only, comes into play because there's a financial penalty. So is the penalty a tax or is it something else? Is it a penalty? So the government's litigating position is it's a tax because, in fact, you would pay it with your taxes that you filed to the Internal Revenue Service. And if it's a tax, Congress has extremely broad taxing power, and so it's almost certainly constitutional. If it's not a tax and it's a penalty, then it has to be justified within Congress's commerce power. So that then raises a question of, does somebody's refusal to enter into commerce, can that be penalized by Congress exerting its commerce power? I'm grossly oversimplifying this, but so this judge in Florida who issued this preliminary ruling, 65 pages worth, earlier this month, says, even though the government says it's a tax, the president on Meet the Press or something when the bill was going through said it's not a tax, and so how can the government now say it's a tax? The president went on television and said it's not a tax. Well, that's ridiculous. I mean, you don't have a federal district judge interpreting some political language of the president on
television.
What matters is what Congress did. That just struck me as quite bizarre.
Well, I mean, I've almost said with all due respect to the Congress, which I swore I would never say again. I don't know where that came from. But this bill was jury rigged, right? So I mean, I disclose again that I would have voted for it, but I mean, the multiple compromises in order to get the votes necessary to pass it suggest a high probability of sufficient ambiguity that's going to result in conflict between different circuits. And I mean, I think it was so rare I never saw it. Somebody in support of the legislation actually giving deep consideration to whether or not it was constitutional. That wasn't really much of a motivator, it seems to be. Though. Anyway, I'm not. We don't have to.
Well, it's worth watching very closely.
No, it really is. I have a fistful of cards. I better not stick on that one too long. Have you read Overmeyer's book, Rehnquist? The question
yes,
is,
I did.
Do you think it's fair? It's a fair portrayal?
You mean that very kind of loving, friendly portrait? That's the.
I haven't read the book, so I don't know if it's loving or not. So
it's if we're talking about the same book, who asked the question?
I did.
So it's a friend, right? A close friend of the late Chief Justice's wrote a kind of a memoir of him, and yeah, I mean it's a lovely book. I mean it's not deep, jurisprudential analysis. It's a portrait of him as a person, and it's got a very affecting portrayal of the last year of his life when he was terminally ill and sort of trying to hang on. So yeah, I mean it's a very human side of Chief Justice Rehnquist, who was somebody who I admired, and I thought he was a very good Chief Justice actually.
This is, oh God, how did you get in? Anyway, whoever wrote this three-part question, I'm not going to be able to get all three parts. Do you think there's reasonable grounds, legal grounds, to support the majority decision in Citizens United?
Yes. I mean, my personal beef with Citizens United is the court really had no cause to go as far as they went in order to resolve the legal issue that the parties had brought to them, which was a specific provision in the McCain-Feingold bill. I mean, my personal opinion really doesn't matter, but if somebody asks me, and I actually had serious constitutional concerns about the provision that was at issue in that case, which was a prohibition on the broadcast of television ads 30 or 60 days before the primary or general election that named a federal candidate, and it was paid for out of corporate or union treasury funds. I thought that was quite problematic under the First Amendment, and I thought it was an accident waiting to happen, actually. And it served up to the court, this fabulous opportunity to go beyond that. So, if I were sitting at the court, I certainly wouldn't have gone as far as the court did, but I might have struck down the actual provision that was at issue, yeah.
Yeah, I mean, I tend to be pretty forceful on the First Amendment, so I was sympathetic to the case. Mm-hmm. One piece that I think actually could come back to the court is they appear to presume to the majority opinion that there would be transparency and that people could see who was making the expenditures. Of course, that is not the case as a result of being able to use 501c3 and C4s as the vehicle.
Well, I mean, the whole campaign finance, it's just a horrible mess. And I think what we've seen, you know, over the 30 plus years since the post-Watergate legislation is there's just huge, you know, motivation to spend money in politics. And if it's blocked off here, it's going to go here. And the legislation is always chasing the last good idea. So these, what are they, 357s or whatever these groups, what's the?
457s.
Yeah, whatever they are. You
Not
know,
that I've
I mean,
used one.
nobody, you know, you're always cooking up a new idea. And
well, this is, I mean, what Citizens did is aligned a corporation's interest with its political interest. In other words, let's say I'm a company and I'm manufacturing ball bearings in a right-to-work state, and I'm paying $7.45 an hour, and you're running for the United States Senate, and you're an advocate of increasing the minimum wage to $11. And I'm the CEO of the company, and I personally agree with you. But as a CEO of the company, it's in my share owner's interest to spend money to defeat you, regardless of what my personal opinions are. I mean, you immediately get an alignment. It's going to be real interesting to see, particularly what public companies do as a follow-on, as to whether or not their share owners will figure out, which right now it's probably a difficult thing for a public company to do because the bills, the decision's unpopular. But it's going to be real interesting going forward to see whether or not that produces even more money coming into campaigns. And from my experience, what the problem is, I mean, take the Delaware Senate race. If the Republican candidate hadn't appeared on Bill Maher 25 times, you know, she doesn't have to campaign at all. And increasingly, that's what's happening. The candidates are sitting there saying, I didn't pay for that ad. I'm not. And the debates occurring in the airwaves, independent of the candidates themselves.
Yeah, I mean, you know, one problem I had with the response to Citizens United, what people who had never paid attention to the way the law was tending on campaign finance with respect to the First Amendment and the rights of corporations, you know, sort of woke up the morning after Citizens United and said, oh my God, you know, how did this happen? Well, it was going on for a long time. I mean, back in the 1970s, the court ruled that in First National Bank of Boston against Bellotti, the court ruled that corporations had a First Amendment right to spend money on public referendum campaigns. That wasn't personal candidate campaigns, but you know, that was a foot in the door. That was a major step, and it, you know, had been unfolding since then. So it was really, there was a big trend going this way, and people shouldn't have been all that shocked, actually.
Well, there's also a tendency to embrace something that you previously opposed if it's in your interest to embrace it. So again, with the president, I mean, the president was in favor of publicly financing presidential campaigns until it became clear that he could raise enough money, and he opted out of the system. And I've done that a few times myself. So talk about it's been a fair amount of attention paid to Justice Thomas's wife's getting not the voicemail message that she left,
please.
But she's raising money from corporations. And the question, there was earlier questions about this, so I just make it more generic than specific to Justice Thomas, who I voted against, but also is a very nice man. I mean, he's not. This is the. But what's the case for recusal? When should if you're a justice, when do you think a justice should recuse themselves and not vote on a case before them?
Well, the law's pretty clear, actually. I mean, the laws on recusal don't actually bind the Supreme Court, but they regard themselves as bound by the laws that do bind other federal judges. So a single share of stock mandates recusal, for instance. So, you know, and I mean, all I know about the Ginny and Clarence Thomas situation is what I read in the Times, you know, that really interesting page one story a couple weeks ago. So you know, it's, it seems to me sort of a matter of appearances and taste, you know. But on the other hand, she's entitled to have a life, and you know, and she's been a political animal her entire career. I met her years ago when she was Ginny Lamp, lobbying on the Hill against the Family Medical Leave Act for the U.S. Chamber of Commerce. And I mean, you know, I'd be the last person to say that because somebody's married to a Supreme Court justice, they just have to, you know, serve tea or something. So, you know, they've got to decide how. I mean, the Thomases have to decide how he feels about it, and I don't think anybody. There's no laws that are being broken, and you know, it's just a matter of taste, I think.
Yeah, I agree with you. Here's a really interesting question. It's long, so I'll read the whole thing. Chief Justice Warren, shortly after he retired, surprised me, not me, but the writer of the question,
Right.
by answering the question of what decision your court made would you be most proud, to which he immediately answered, one man, one vote.
Mm-hmm. Baker against Carr, yeah.
Right. And Chief Justice Berger and Rehnquist are no longer among us to pose the question. Chief Justice Roberts is early in his career on the court. What the question is, if the question were posed to him, what legacy would you like your court to leave? What do you think his answer would be?
Well, that's interesting. I mean, he's just the umpire calling the balls and strikes. So, you know, I mean, he disavows any desire to leave an affirmative legacy. I mean, if I could amend the question to say, what's the most telling opinion, what opinion of his tells us the most about him as a judge, I would say it was his opinion for a plurality of the court, not a majority, because Justice Kennedy wouldn't sign. In the parents involved case in 2007, the Seattle and Louisville school integration cases, where the question was it constitutional for these two school districts with a history of de jure segregation, democratically elected school boards in these two school districts with this very painful history of segregation, that they couldn't do it. And just flat out couldn't do it. And Justice Kennedy, who has never voted for any government program that counts people by race, was sufficiently upset with the categorical nature of the Roberts opinion that he refused to sign it. He agreed with the result, but he filed a separate opinion and said, you know, this question is just a little more, or not a little, this is a lot more complicated. I mean, what the Roberts opinion said was these two school districts had the term of art is compelling interest, no compelling interest in taking these measures to maintain integration. And Kennedy said, of course they have a compelling interest. The question is whether these particular measures are sufficiently tailored to serve that interest. And Kennedy thought they went too far or were too, you know, sloppy or broad or whatever. But he said, of course there's a compelling interest. And I think, I mean, that, to me, so far, John Roberts just passed his 5th anniversary as Chief Justice. That's the singular opinion that tells us about his jurisprudence, that he couldn't meet Kennedy on those grounds and say, you know, we don't have to even decide whether there's a compelling interest. Assuming arguendo there's a compelling interest, these plans are not reasonably tailored, and he could have gotten 5 votes for that and spoken for a court, but he wouldn't do it. Really, really important case.
There's several cards in here, maybe all the remaining cards. I want to look at the top 2 or 3 that talk about the Bush v. Gore decision, which was I would say maybe in the last 20 years the best-known case that the court has decided. Certainly the most controversial case is decided. And as you know, it was decided with a declaration that it can't be used as a precedent in the
True, and hasn't been.
Right, well, yeah, right, and probably won't be unless
we get real unlucky.
right, unless we get real unlucky. And Breyer, and Breyer in his book expresses pleasure at the fact that the American people respect the decisions of the court even when they disagree with them. Citizens United is actually is another one. But the questioner here finds no such pleasure in it because he views it as almost a coup d'etat. That's the language, again, on the card. But it seems a rather significant reversal for people like Scalia, for example, to take this case and intervene the way they did.
Yeah, well, I have complicated opinions about Bush against Gore. I mean, I don't think it was a coup. I think, well, for one thing, of course, the American public had a chance to express buyer's remorse about it in 2004, and they chose not to. So I don't think we can necessarily blame the court for, the second Bush term, for instance. But, I'm willing to assume that the 5 justices in the majority really thought they had a mandate to act as they did. I mean, do I think they were correct? No, I don't. But I don't think that 5 of them woke up the morning after the election and said, by God, we're going to do whatever it takes to install a Republican in the White House. I think they were sort of hardwired because of the way they responded to the kind of chaos that was building up, that they said, well, this is within our jurisdiction. Ted Olson was a very good lawyer. He threw a whole bunch of stuff up against the wall, all kinds of legal claims to see if anything might stick, and I was pretty much of a shock that what stuck was the 14th Amendment. That seemed like the last thing. But, it was there for the taking, and so 5 of them took it. But, do I think it's the worst thing the court ever did? No, not really. And neither does the public. I mean, one thing that Breyer says in this book, and it's true, is that the social scientists who do the kind of longitudinal polling of how the court stands in the opinion of the American public, the court didn't really take much of a hit for Bush against Gore. I mean, progressives are always sorry to hear that, but I think...
Well, it was a closely decided election, so it's not...
Yeah, exactly. So half of the people were happy just, from the get-go. But it was just like a weird... I wrote a law review article, and I analogized it to a bad hair day. It was just something weird that happened. And,
Yeah, I mean, personally and strongly so, did not see a constitutional crisis in the making that necessitated an intervention. And I'm
I didn't
relatively
either.
confident that
Yeah.
if it was a different kind of an issue, the Scalia would not have voted to intervene.
Oh, listen, I told 1 million readers of the New York Times on page 1 that the court was never going to take the case, so I had a stake in their not taking it, but,
How do you think a marriage equality case would fare before the Supreme Court?
Well, I think it really would come down to Anthony Kennedy at this point, and one thing that was pretty brilliant about Judge Walker's opinion in the Prop 8 case is, and again, we don't know what's going to happen in the Ninth Circuit or whether this case is even going to get to the court, but Judge Walker gave basically a 2-part analysis of what was wrong with Proposition 8. One was a kind of a narrow Prop 8 specific ruling that said that the campaign that was waged against same-sex marriage in California was built on stereotypes and a lot of, very stereotyping rhetoric about gay men and lesbians, and that the political process was basically hijacked with a lot of animus. And that's a claim that resonates with an opinion by Justice Kennedy in a case from Colorado, the Romer case, where the public of Colorado had adopted an amendment to their constitution that said that basically no gay rights claims for legislative protection could be enacted in the state of Colorado. And Kennedy wrote an opinion for the majority about 10 years ago who said that's unconstitutional. That's a violation of equal protection. You're carving people out of the ability to basically petition the government for, their assistance. So if you look at the same-sex marriage issue coming out of California as a Romer case, I think you could plausibly get Justice Kennedy and 4 others to agree. Judge Walker also gave a very broad, swath of constitutional protection for the claim that's more, maybe more problematic in the view of the Supreme Court, but I don't know. One thing that's very strong about that opinion is he said, look, we're talking about marriage, and marriage today isn't what marriage was, even 5 or 10 years ago. It's a very dynamic social change that he said basically the court is not creating, it's simply recognizing. And if it takes a couple years for this case to get up to the court, that process will continue. The polling now, for the first time, is now a majority of the public approves of same-sex marriage. Slight majority, but a majority. There's been no great uprising in the wake of the Proposition 8 ruling. And I think the court is attentive to public opinion, not slavishly, but the court over time situates itself kind of in the mainstream of public opinion. So I would really hesitate to say one way or another on this, but it's really interesting.
Yeah, but speaking of just the opinion of others in this case, in Jeffrey Toobin's book, The Nine, he asserts that Anthony Kennedy's travels to Europe and his association with, I think, members of the bar, European bar, impacted his view in the Texas sodomy case. Do you think that's correct? And if so, do justices, you wrote, that Harry Blackmun became Harry Blackmun over time. Do they change as a consequence of experience over time?
Do justices change? Some justices change. There's a lot of study about this. So political scientists have looked at justices appointed by Republican presidents since the mid-20th century, which of course is most of the court.
Black certainly did. Black certainly changed.
A number of them have changed. So the question is who does and who doesn't. And Michael Dorff from Cornell has a good article about this. And he looked at, I think, 10 Republican appointees to the court since mid-century. And the ones who, quote, evolved to the left were those who, like Harry Blackmun, like Sandra O'Connor, like Lewis Powell, arguably, and Anthony Kennedy, and David Souter, came from outside the Beltway, did not have any previous federal government experience, hadn't got their ticket punched in federal government,
I think it's a
underwent the kind of, mind-expanding experience of moving in midlife to a new culture as a Supreme Court justice, and kind of shakes you up a little bit and makes you open to new ways of looking at the world. The ones who didn't change, say a Warren Burger, a William Rehnquist, people who they hadn't spent their childhoods in Washington, but they'd spent their adult lives in the federal bureaucracy in some way. John Roberts, when he got his promotion to the Supreme Court, his daily commute grew by about 3 blocks from his home in Chevy Chase. He's not likely to change at all. Sam Alito, although he was a judge in New Jersey, his formative legal years were spent in Washington. I don't think he's ever cashed a paycheck that wasn't issued by the federal government. I think he's not too likely to change, but it's a small number to build great theories on, but it's an interesting inquiry.
Not some of the best theories are based on small numbers. What do you think of the freedom of the press as the sort of the fourth check on the legislative, judicial, and executive branch?
What do I think of freedom of the press? I'm for it.
No, but well, okay,
What do I think of?
How important is it?
I think it's really important. I'm all for it.
Oh, come on.
I don't know what more to say to that.
Let me help you on this a little bit. There's one very large area of government activity that the press has very little access to, and it's those parts of the national security infrastructure that are classified, and it's very, very difficult. And I've had a fair amount of experience in that area, and you can really see the differential. For example, it's 15 years ago on the Agriculture Committee, and I'm on the Intelligence Oversight Committee, right? The best oversight from time to time, not always, because sometimes it was the worst oversight, would be a piece of fair investigative journalism of something that was being done at the United States Department of Agriculture. And it would provoke a hearing on the matter, food stamps being abused, something wrong with the Soil Conservation Service or the Forest Service, something that USDA is doing. It's rare. In fact, recently, Dana Priest's story that she did in a 3-part series that I thought was going to be explosive. It's almost no follow-up because it's very difficult to do any follow-up because you don't have a right to get access to it.
Wasn't she the reporter who broke the story about the renditions of,
She broke the stories, and her biggest story prior to that was breaking the story on Walter Reed. She broke the Walter Reed story, the sort of warehousing that was going on in a building adjacent to Walter Reed. But this was an extensive amount of research on the approximately $70 to $80 billion worth of expenditures.
All the black budget and all that.
Right, the entire black budget. So I mean, as somebody who's both benefited from and suffered from the press, I have a very acute sense of the importance. And so I agree with the questioner. And maybe you don't, you say, so I'm trying to pull you out a little bit beyond, I'm for it here.
Well.
I don't think I can pull you out.
No, I mean, it's such a broad question. I mean, I don't,
will Sotomayor's appointment affect the court's decisions on state church matters?
On what?
On church-state, on First Amendment issues, on separation issues.
I mean, because she's the Sixth Catholic? Is that the premise of the question? I don't think she's got a record on church-state
Who wrote
issues.
this question?
What do they mean by that?
I don't know what it means.
I guess
Okay,
we'll
moving
see,
along here.
Yeah.
Well, that's another health care bill. Oh my God. Was Anita Hill telling the truth? Well, of course she was. Citizens United impact, I think we've already covered it adequately, that's right, okay. Here's an interesting question. Should the Constitution be changed to limit the terms of the lifetime appointment of a Supreme Court justice?
Was my opinion of this?
Yes.
I think it's worthy of debate. I've actually done a fair amount of reading about it, and
Okay, I'm against it. Which side are you on?
I'd be willing to have a good public debate about it. I mean,
We're having a debate on it.
Right, well, I mean, you could argue that when the framers said, tenure during good behavior, that is life tenure, they didn't envision people staying on the Supreme Court for 35 years. They envisioned the court as being a capstone of a distinguished public career.
But I must say, I've seen more evidence of people staying beyond their capacity to make decisions in the Congress than I have in the court.
Oh, I think that's right. No.
Meaning they got elected. They faced the voters and got reelected.
Yep.
You mentioned one earlier.
Right. No, I mean, I don't mean that they stay so long that they become incompetent. It's just that it greatly affects, for instance, the heat of the nomination and confirmation process, because the Senate knows and the public knows that you're confirming somebody who's likely to far outlast the tenure of the president who appointed that person, and so it's a projection of, that president's desire for decades down the road, and it keeps the heat on, and the heat of these confirmation hearings just goes up and up and up. So the most serious proposal that's out there, and it's a very serious proposal. Whether it's going to get anywhere, I doubt. But I mean, a lot of very thoughtful, serious students of the court have signed on to this. Would have 18-year terms, and it would be staggered in so that in every presidential 4-year term of office, there would be 2 vacancies. And so the idea being that this would be regularized. And so you wouldn't have, say, in a presidential election cycle, You know, when there's several elderly justices who plausibly would be retiring in the next 4 years, it wouldn't be like a huge campaign issue. Who's going to get control of the court? Every 2 years there'd be a vacancy, and you know, the system would sort of learn to accommodate this, and it would just kind of lower the temperature. I mean, that's the impetus, not that old justices are incompetent. I mean, that's not a problem these days, because there is enough transparency. You wouldn't have a William O. Douglas on the court as he was in the last year or two of his life, and he was not competent, but you know, the public wasn't that much aware of it. Those days are over, so that's not the problem. It's how the court fits into the whole political system, and it's just very interesting. I mean, when I first heard about it, I said, that's ridiculous. Life tenure is one of the jewels in the crown of our democracy. It's not necessarily true. It's worth thinking about.
What do you think, Bob? Since we're going to have a debate here. Bob Mondheim used to be the dean of the University of Pennsylvania Law School, and now is a member of our board.
I said, I don't think you can just look at the Supreme Court. We're looking at the whole federal court. And certainly there you've got examples of people who stay beyond their time. I think the other question is whether or not term limits doesn't generally have a good effect.
Yeah.
I mean, we've begun to take that view on the Board of Trustees, at least with respect to service on some positions on committee heads. And I think that makes sense.
Yeah. No, I think the broader question of the federal court really is the most important question, because I have not been in the debate. I mean, I really don't. I don't hold a strong position on either side. My immediate reaction is the one you have. The burden, in my case, the burden would be on an advocate for imposing a limitation on terms. And as yet, they've not persuaded me that the Constitution needs to be changed.
You know, it's very interesting that.
In fact, the only part of the Constitution I'm actually willing to entertain changing is Article 1, because I think the way we select Congress is suspect.
You want to repeal the 17th Amendment like the Tea Party people?
Well, I will say this. I don't think Webster, Calhoun, or Clay would have been elected by the people in a direct election in their states.
Yeah.
So when we make a list of the great senators since the founding of the country, you've got on your list people who were selected by state legislatures, not people who were elected directly by the people. So I've not come around to that, but I certainly look at the current requirements for eligibility. I mean, for example, I'd like to see political equivalent of an SAT test be required, not to become eligible, but so the voters can make a decision as to whether or not somebody actually knew enough and make their own judgment. You could vote for somebody that got a 10 on the SAT, 100 being perfect.
Maybe we should require an IQ test of the voters.
Well, that's another interesting question. I remember when the voting age was lowered, and the argument then was if you're old enough to go to war, you're old enough to vote. And thinking at the time, I wouldn't mind it if you raised the age at which you would go to war. That's kind of, maybe we did the wrong thing at the time. I don't know. I mean, I think that it's very difficult for me to come around to supporting changes in the Constitution because it's worked.
Well, I'll make one more point about life tenure. I mean, it's interesting that the rest of the democratic world has adopted many of the features of our government, including judicial review and so on, but there's not a single country that has adopted life tenure for its judiciary. That's something that has been universally not followed. And among the states, there's only, I think the only state in the country that has life tenure for its state high court is Rhode Island. Every other state either has term limits or age limits. So, the world and the states have voted with their feet on this. And
I must say, I don't find myself admiring the judicial system of any other country better than I do ours.
Well, Canada's not bad. Canada's pretty good.
Well, that may be damning them with faint praise. I mean, I don't think Canada's bad. I'm not saying asserting that they're bad. I'm just saying I don't begin with saying, gee, there's somebody doing it better than we are. As flawed as our system is, I'm not saying it's...
Yeah. Anyway, I mean, it's, you know, you and I share the same visceral reaction to the idea, but I think it's worth further pondering.
It's 7:30. It's time to go. Let's...